know whose voices they were?
I believe they were my sister Raquel, my friend Tweety, and it may have been my niece Lily. So between those three.
What was the nature of those voices? How did they sound?
They sounded long distance.
And do you remember anything else from the scene that day?
No.
What's your next memory?
Waking up in the hospital.
Okay. Did you know where you were?
Kinda. I had my eyes squinted and I seen the surroundings, knowing that I was in a hospital room.
Okay. Was anyone with you?
My sister Raquel.
Do you know how long after the crash you initially woke up?
No.
Do you know how long you were in the hospital in total?
My sister and my family members told me it was 3 days or 4 days.
Okay.
4 days.
And you don't know how long you were out of consciousness?
No.
Did you receive any injuries as a result of the crash?
Yes.
What were those?
I had 6 broken ribs, a collapsed lung. I was missing a tooth. I had mouth injuries. I had a cut on my chin. My lips had to be stitched back together. I had a hematoma. I had a broken shoulder blade. And I had a concussion.
Are you still dealing with those injuries, or are they all healed?
I'm sore still, but I'm getting therapy.
Do you have any trouble breathing still from the ribs in your lung?
It's discomfort.
Okay. Was there any intervention for the collapsed lung? Did they do anything to your body because of that?
I had a chest tube put in
Okay. Like through your throat or?
through my rib cage.
Okay. So they had to cut you to put a chest tube into your lung?
Yes.
Your son Jaden was with you at the party.
Yes.
Do you have recollection of him being at the table with you and Zane and Alana?
I am not sure.
Okay. What's your last memory of Jaden and his location before the crash?
He was, I want to say close by the table, but he wasn't sitting at the table.
And he's your son, correct?
Yes.
And how old is he?
12.
Okay. And do you know if Jaden was hospitalized as a result of the crash?
Yes.
Okay. Do you know how long Jaden was hospitalized?
2 weeks.
Okay. What injuries did he receive?
He had broken ribs. He had several broken bones through his body, on his legs. He had a deep cut in the back of his head. It had to be stapled. He also had a collapsed lung as well as a chest tube. He had a broken pelvis.
Did he have to have any, for lack of a better medical term, hardware put in for the broken bones?
Yes.
What was that?
There were rods put in both of his legs.
Okay. And obviously you had to have surgery for that.
Yes.
Okay. How is Jaden doing now?
He still can't walk.
Okay.
He's in a hospital bed still in our living room.
So you have to have home care for him?
Yeah.
Is he in any kind of therapy right now? What kinds?
Physical therapy, occupational therapy, and he has regular nurses that come. And he has appointments outside of the home, getting x-rays to see the status of his injuries, to see what the next step is for him to walk, to try to walk.
Judge, I don't have any further questions.
Cross-examination.
I don't have any questions, Your Honor.
May the witness be excused.
Yes, Judge. And Your Honor, at this time, I call the court's attention to the stipulated exhibits. 15 medical records for Mariah Dodds and 16 medical records for Jaden Phillips that were previously submitted to the court through stipulation.
Both are admitted through stipulation.
Thank you, Judge.
People may call their next witness.
Judge, people call Detective Josh Modelinsky.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
You may be seated. Detective, please state and spell your name.
Detective Josh Modelinsky, JoshMotylinski.
People may proceed.
Thank you, Judge. Detective, it's redundant, but what is your job?
I'm a detective with the Monroe County Sheriff's Office.
Okay, how long have you been a detective?
I've been a detective just over 2.5 years,
Okay, and how long have you worked for the Monroe County Sheriff's Department?
12 years.
Did you have any other jobs in law enforcement prior to that?
No.
And you were so employed on April 20th of this year,
Yes,
and you're a certified police officer, entitled to be a police officer in the state of Michigan,
yes,
and you were at that time as well.
yes.
What is your role in this investigation?
I was the detective on call on April 20th. My supervisor, Detective Sergeant Hooper, called me a little after 3 o'clock and advised me of the situation at the Swan Boat Club and asked me to respond from my house in my unmarked patrol vehicle.
Roughly where did you respond from?
My house is located in Temperance, Michigan, right around the area of Lewis and Temperance Road.
Okay. So, and then where's the Swan Boat Club located?
It's up in Newport off Branch Hall Road.
Okay. To get to the boat club, did you face any physical impediments?
The highway, which I typically get on at Luna Pier Road, it was closed off due to construction. So I went a different route. Went through the city of Monroe to Elm Street to North Dixie, out toward the boat club that way.
Once you got out near the boat club into the neighborhoods that surround it, are there any fences or gates or anything that blocked your entry?
No.
The boat club is accessible to the public.
Yes,
Anyone can drive that.
yes,
So you're the officer in charge of this case, is that correct?
correct.
So once you arrive on the scene, what do you do first?
I meet with the other deputies and supervisors on scene to get a rundown of the situation, as I was not a first responder. Got a baseline of what kind of happened, and then my job from there was to do the medical examination investigations of the 2 deceased children that were at the scene.
And do you examine the scene as a whole?
Correct. Yes.
From your examination of the scene, are you able, as far as the named victims in this complaint are concerned, able to tell us where within the venue they were located
After the crash.
after the crash?
Yes. After the crash, Edward Smothers was in the breezeway between the boat club and the bar area of the pavilion, or the pavilion and the bar area of the actual boat club itself, that breezeway. Miss Dodds was also in the breezeway. She was pulled out from underneath a door that had come off the hinges going into the pavilion.
And the other living victims, Miss Stiff, Miss Medina, and Mr. Phillips, where were they located?
Mr. Phillips was located behind the bar in the pavilion, towards the front end of where the car had entered in the building and stopped at its location. Miss Medina was against the bar in the pavilion, probably on the ground in, I would approximate the middle area of the bar. And then Miss Stith was also against the bar, farther away from Miss Medina in the car towards the end of the bar.
You indicated a moment ago that you did the medical examiner investigation in this case.
Correct.
And what is a medical examiner investigation?
Anytime somebody passes away of unnatural causes and the doctor won't sign a death certificate, one of our detectives who are trained to be a medical examiner investigator have to go out and make sure there's nothing suspicious and basically examine bodies and do a scene overview for the coroner's office so that when we send the bodies down to the coroner's office, the doctors that do the autopsies and such have a understanding of the scene and what happened, the situation by the person became deceased.
Okay, so the idea of the investigation is to give a context to the medical exam.
Correct.
Right?
Correct.
And that happens in both crime scenes and non-crime scenes.
Correct.
And this obviously was a crime scene.
Correct.
And you conducted a medical examiner investigation here. Is that correct?
Correct.
And what was the nature of that? What were your findings?
I found there were 2 juvenile decedents that we shipped down to the coroner's office. After the coroner did their autopsies, I received reports back for both Zane and Alana. The cause of death for Zane.
Well, just 1 second on that. Let's talk about your investigation first, a little bit before we get to the results. First as to Zane, where was he located in relationship to the crash? Where was he found?
After the crash occurred, he was located pinned between the front driver's side tire and near the wall area where the car came to a rest.
Okay. Was he still there when detectives and law enforcement arrived?
He was not. Several civilians had lifted the car and pulled him out, and they took him out out of the pavilion where the vehicle entered onto that grass area where medical personnel arrived.
Okay. As to Alana Phillips, where was she eventually located?
Lana was located on the.
Judge, people believe that this is self-authenticating document under 76611B. Move for its admission.
Your Honor, I thought when we discussed this that I stipulated to the medical examiner's reports that there was, that we'd stipulate to the entry.
Oh,
And
I
there was
believe
no
we did do
debrief.
that, Judge. It's also
Correct,
self-authenticating.
you were all stipulated to,
Right, okay,
it's
thank you.
admitted for stipulation.
Thank you, Judge. And just as to that, Detective, could you just review that document and proffer for the court what the cause and manner of death is?
Yes. Cause of death is multiple blunt force injuries. The manner of death is accident.
Thank you. Detective, I'll hand you this second document. And if you could tell the court what the title of that document is.
Lucas County Coroner's Office case summary on the death of Zane Isaac Phillips.
In your honor, same situation here. If you believe it's self-authenticating by statute and it's been stipulated to by defense.
That's correct, Your Honor, we stipulated to it. I think there's a court order to that effect.
It's admitted pursuant to stipulation.
Thank you, Judge. And Detective, same thing here. If you could just review that briefly and proffer for the court what the manner and cause of death in this case is.
Cause of death, multiple blunt force trauma, and in parentheses it says second - minutes. Manner of death, accident.
Thank you, Detective. Judge, I don't have any further questions for the detective.
I mean,
You may proceed.
thank you, Judge. Officer, you said the autopsy reports that you just read, that the manner of death was accidental, am I correct?
That's what the coroner's office ruled. The manner of death is yes.
I don't have any other questions.
Any redirect?
No redirect, Judge.
You may stand up. People may call their next witness.
Judge, at this time, people have no further evidence to present.
Do the people rest?
People do.
Any witnesses for the defense?
No, Your Honor.
Does the defense rest?
Defense rests.
We proceed with motion and argument.
Judge, people move to bind over on all 9 counts in the amended complaint. Your Honor, people believe they've established date, venue, and the identification of the defendant. Throughout the course of this exam, the court had an opportunity to view body-worn cameras from Sergeant Bomia and Deputy Karina. In both of those body-worn camera videos, the defendant acknowledges her operation of the vehicle at the time of the crash. People's exhibits from the Michigan State Police Crime Lab indicate an intoxication level of 0.18 blood alcohol. Those lab reports were statutorily admitted. The people also submitted a second lab report that indicates a finding of gabapentin in the defendant's blood at the time of the crash. The ME reports, the medical examiner reports that were just admitted, established the cause and manner of death as to the decedents, Zane and Alana Phillips. Both died as a result of multiple blunt force traumas as a result of a car collision. People believe that the medical records entered and the testimony of the live victims here today establish a serious impairment of body function sufficient to show probable cause for counts 5 through 9. That's taking from MCL 257.58C. People believe that the broken bones, punctured lungs, major bone breaks, loss of consciousness, kind of established by all the victims, qualify as a serious impairment of body function under the statute and meet that element. The medical records, medical examiner's reports, videos, defendant's admissions, and the victim's testimony illustrate that the deaths and injuries in this incident were a direct result of the defendant's operation of the motor vehicle. Defendant's operation was the factual and the proximate cause of the deaths and injuries in this case. People believe there's ample evidence to support a probable cause finding of that conclusion. People believe that that establishes probable cause on counts 3 through 9. As to counts 1 and 2, other than the proofs previously noted, the people have established probable cause that victims Zane and Alana died as a result of defendant's actions. People have established probable cause for the court to find that the defendant knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. To that end, Judge, evidence presented today shows that defendant possessed a BAC of 0.18, the legal limit in the state of Michigan being 0.08 for an OWI charge and 0.17 for a high BAC OWI charge over both of those limits. The defendant acknowledged in her interview with Deputy Karina that she should not have been driving. In People versus Gecki, Judge, 457 Mish 442 1998, the Supreme Court found that both of these factors can be considered by a finder of fact to support a second-degree murder charge in a traffic or drunk driving case. Further, Judge, evidence was presented that the defendant operated her vehicle at an excessive speed, that being nearly 45 miles an hour through a parking lot or a private drive, where at best the speed limit is 25 miles an hour. Excessive speed was held to be a factor to support that the defendant created a high risk of death or great bodily harm in People v. Aldridge. That's 246 Mishap 101 2001 case. Further, Judge, defendant left the scene of a property damage accident right in front of her house. That's by backing into her neighbor's truck in front of her driveway. That's the video that the court saw provided by Detective Hoover. In the unrecorded case, Judge, of People versus Del Piano, a 2012 case by the Michigan Court of Appeals that can be found at Westlaw 3046157, found this to be a factor supporting second-degree murder charge in an OWI incident. And finally, Judge, the Gecki case notes that in cases of this nature, in order to sustain the intent element for second-degree murder, the incident should have an overall egregiousness quality. Here, people point out that the defendant's BAC was not only twice the legal limit, but she also had gabapentin in her system. She acknowledged to Deputy Karina that she was intoxicated. She scored herself a 7 out of 10 for intoxication. Further, the defendant left her home in her condition, knowing that she was traveling to a small child's birthday party. The defendant was aware that there would be small children at the boat club that day, maybe not just inside, but maybe also in the parking lot. This was not an ordinary drunk driving crash, Judge. The defendant did not run a red light and strike a car going in the opposite direction. She did not fail to stop in an assured clear distance and rear end someone. She drove her car at almost 45 miles an hour through a building where dozens of people, many of them small children, were having a birthday party. People believe that those factors satisfy the overly egregious quality cited by the Supreme Court in Gecky. For that reason, people ask that the court bind over on all 9 counts.
Thank you. Argument from the defense.
Thank you, Your Honor. I think it's unquestioned or substantiated that my client suffered from neuropathy and seizures, that she had a history of it. There was nothing to prove otherwise. The officer testified he received through a subpoena the medicals. They're asking for second-degree murder. Your Honor, second-degree murder has some sort of intent involved. There's been absolutely no intent proven through any of the evidence, stipulated or otherwise. It's either that intends to kill the victim or cause severe harm and not with premeditation. The statute right on point. So there was no intent by my client whatsoever. And then second is, did my client intend to cause serious bodily harm that death could result? There's no testimony whatsoever that my client operated her vehicle with the intent for that to occur. If this was a crowd in a parking lot, in a street, and she didn't like somebody in the crowd, as an example, and she wanted to hit that person, and she ended up hitting several people or another person, then that would be second-degree murder. There's an intent to operate the vehicle, her vehicle, in such a manner. There is some intent. There was no intent whatsoever here. There's been no proven. In fact, when the officer sat my client down and conducted an interview and had the body camera from the other officer on, my client spoke just like we're speaking today. There was no slur. There was no, what's my thought? I don't know where I'm at. I don't know what's going on. And a slur that would accompany such a high blood level of alcohol. And so I proposed to the court that had the blood sample result properly been, and I understand, Judge, when I say properly, I don't mean to draw anything to the court. The court followed the statute that the results are self-admission, are authenticating. But if the person that did the draw was here, if the person that did the testing was here, I don't think it would be proper of the 0.18 or what's been openly thrown about in the courtroom. I asked the officer, was there a seal? And the officer says at first, several times, I don't know. Well, of course there's got to be a seal on these. They have to be sterile. So then finally he did say that there was something white on it, even though he's done this several times. So then I asked him, well, how was it sent? And he didn't have a good memory at all on that. And he's the one that's in charge. He's the one that's in charge of drawing the blood, which is extremely serious of whether proving my client's guilty or not guilty, or should even be charged. If somebody has a history of medical issues, that she was even hospitalized in November of 23. Nobody told her not to drive after 6 months. She waited 6 months and a couple weeks after that to drive. Your Honor, there's just no evidence whatsoever that she acted in a manner that would cause a death. We know for sure that the vehicle was driving at a higher rate of speed, whether it be 43, 44 miles an hour in an area that's 25 or 30 or something like that that was mentioned. There's different speed limits. So that would be about 10 over, 15 over about, depending on what's the correct speed in that area. She didn't, there's no proof that she intentionally put her foot right down there and just go right into the wall. What it does make sense is that she did have a seizure and neuropathy that freezes her feet and hands down seconds wise. That's what it does make sense. Because here's this person with a perfect record in 50 years that all of a sudden is pushing it to the floor to take off to go right to the boat club where she served as Commodore, where she's going to, for the birthday party, where she knows everybody there. Just doesn't make sense. Yeah, I understand there's a lot of questions of fact, Your Honor, I respect that, but it's just not a murder too. It just doesn't rise to that. It doesn't, you know, they don't go up to her right afterwards and say, you know, why'd you do it? And she say, that son of a gun, I wanted to get it. Or I'm ticked off at the boat club or whatever. None of that. She's very calm. So it doesn't rise to the level of this intentional. And that's what it is. It's intentional. The others are general intent, drunk driving and things like that. But this is intentional. The actions have to be, because it carries up to life. So it's going to be pretty serious. And so the actions just aren't there, honestly, Judge. And I don't even think it rises to the level, well, it's a question of fact. Or else everybody could be charged that there's an accident, somebody seriously hurt with murder too. It's a question of fact for the jury. Judge, respectfully, this shouldn't be a murder too. There's other counts of is there a serious injury and things like that based upon the blood alcohol level of the report itself, and that's it. I understand, and I respect the court on that. But murder too, it's just not there, Judge. And then lastly, you know, I ask questions, is this area open to the public? Because drunk driving on private property, if it wasn't, I dispute it fully. It's not private property and not public. And if I may just have one moment, Your Honor. The police executed the search warrant and found that she had consumed, according to her testimony, 1 glass of wine.
Objection, Judge. I'm sorry, what testimony would that be?
Well, I believe you're stating facts, not in evidence.
Okay, I thought that she had said that she had a glass of wine, and I apologize. I thought that was said. The court would know if it was, and it wasn't, but it's in the report somewhere, but I understand it's not before the court. So they're interviewing her, Your Honor, after she had just gone through a wall at 40, 44 miles an hour. Now they're interviewing her and they're asking her questions. I don't know if any of us would be in the right state of mind after we just went through a wall with our car at 40 miles an hour. So they're interviewing her, Judge, and they're asking, do you feel you could operate a motor vehicle? Well, of course she said no. I can't operate a motor vehicle. She just was in a collision 15 minutes prior, 20 minutes prior. Then they ask her, you know, alcohol or whatever wise, you know, 1 out of 10, where do you put yourself? She doesn't even, just imagine going through a wall and then 20 minutes later somebody say, how do you feel? Okay, so I don't know about her having her faculties, and I understand that could be a question of fact, certainly, Your Honor. But the murder too, we just really argue strenuously that it just doesn't exist. with regard to this record. Thank you. Nothing further.
Any rebuttal argument from the group?
I know the court knows this, but I just draw the court to the third state of mind available in murder two, which is a defendant knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of their actions.
In the operative word, if I may,
The people get the.
Oh, I'm
they
sorry.
have the verb.
I was gonna say, knowingly.
Right, this is a preliminary examination. The standard of proof is probable cause. I've heard the testimony presented by the people. I've reviewed the exhibits, seen the video. It has, this evidence has been uncontroverted today by the defense. As to count one and count two, homicide, murder in the second degree. The evidence has established by probable cause that both of the victims named in the complaint died an unnatural death due to the crash caused by the defendant. The question then becomes intent. Under common law and under Michigan law, you do not need to intend to kill someone to be convicted of second-degree murder. It can be done with depraved indifference to human life or with depraved heart. And Michigan is defined as knowingly creating a very high risk of death or great bodily harm, knowing that that death or harm would be likely result of her actions. In this case, the defendant was operating her vehicle with a blood alcohol level of 0.18, as admitted today. She was driving at a high rate of speed, almost 45 miles an hour in a 25-mile-an-hour area. She did this after she crashed into another vehicle, as the video showed. She was accelerating towards the building where the victims were located. Reviewing those factors, I do find she acted with depraved indifference to human life. Therefore, I am binding over on count one and two, murder in the second degree. As to counts 3 and 4, operating while intoxicated causing death. Find the following: defendant was operating a motor vehicle. She did operate it on a place open to the public or generally accessible to motor vehicles. Under the statute, that also includes any designated parking area. The evidence does show that. Third, the defendant was intoxicated. The evidence shows that her blood alcohol level was a 0.17 at the time of the offense. Fourth, the defendant voluntarily decided to drive knowing that she consumed alcohol. The evidence circumstantially does prove that. Fifth, that the defendant's operation of the vehicle caused the death of the two main victims as to these counts. And that but for the defendant's operation of this vehicle, it would not have occurred. I do find that her actions are the direct and proximate cause of these victims' death. As to counts 5, 6, 7, 8, and 9, operating while intoxicated causing serious injury. Incorporate all of my prior findings as to those elements. I also find all of the named victims through their testimony and through the medical evidence shows that there has been a serious impairment of bodily function as defined by MCL 257.58C. Therefore, the defendant is bound over to the 38th Circuit Court to stand trial on all charges. Would you like an arraignment on July the 5th or July the 12th?
I'm sorry, Your Honors, you said July 5th or what date?
Or the 12th, it'll be at 9 a.m.
July 12th at 9 a.m. That sounds good.
And it will be arraigned in the 38th Circuit Court on July the 12th at 9 a.m. Anything else to address at this time?
Not from the people. Thank you, Judge.
Not Your Honor.
Court is adjourned.
All rise. Court's in recess. You may be seated.